Hello, everyone. Good morning. Welcome to the 18th International Conference on Artificial Intelligence and Law. Now, for our third day, I would like to first initially present our sponsors. So, Jus Brasil is our platinum sponsor. It's currently the #1 law and government website worldwide that makes high-value legal information easily and quick to access. And also, Albert Einstein.
Everyone. Good morning.
And also,
Welcome
Albert
to
Einstein
the
Israeli
18th
Hospital.
International Conference on Artificial Intelligence and Law. Now, for our third day, I would like to first initially present our sponsors. So, Jus Brasil is our platinum sponsor.
And also, Albert Einstein Israeli Hospital, our platinum sponsor, is one of the best-known health unities in Brazil and Latin America. Finally, I would like to thank our silver sponsors, Opsi Bloom Lawyers and Oasis Open. Now, directly from France, we have our first one full paper presentation. I would like to call to stage Mrs. Haja El Hamdani with a combined rule-based and machine learning approach for automated GDPR compliance checking. Please, Mrs. El Hamdani, the stage is yours.
Hello, everyone. Let me first share my screen for the presentation. So can you please confirm that you can see my slides? Okay, great. So I'm happy today to walk you through our research project about automating GDPR compliance checking. It is a research project in collaboration with researchers from HEC Paris and Oranova. So our work comes from the context of complying with the data protection laws. So complying with the GDPR is challenging, and one of the reasons is that personal data flows in complex data supply chains. And although companies are using technology to deal with this complexity, there isn't a comprehensive framework defining end-to-end compliance. So the objective of our research is to fill this gap by first building a conceptual framework for GDPR compliance, and second, to test this framework by automating the compliance checking of privacy policies against the GDPR. The framework that we developed is document-centric because the GDPR entrusts documents with different functions. For example, controllers and processors must maintain a record of processing activities according to Article 30. So the starting point of our framework are compliance documents that we define as documents that establish the conditions and processing activities that data controllers and processors are intended to and should carry out. Such documents are privacy policies and data protection addendums. It could be also contracts containing clauses about data protection or internal company documents. And so these documents, we suggest that they should be automatically analyzed. First, to ensure their compliance with regulation, both on a functional level and substantial level. Then the documents should be compliant in the data supply chain, which means that we verify the documents in the light of contractual standards or another document with a higher hierarchy in the supply chain. And last, we assess the adequacy between operations, documents, and regulations, so that we also ensure that operations of processing personal data are compliant with the regulations. To test our framework, we first apply it to analyze privacy policies compliance in the data supply chain. And we start with privacy policies because they are the compliance documents that appear at the top of the data supply chain, since they communicate information to data subjects. And we define the tasks to check for formal compliance, which is the first level of the compliance framework we suggest. And the tasks that we end up with are the checking of the presence of mandatory information according to Articles 13 and 14, and also the readability and clarity of the language, which is defined in Article 12 of the GDPR. And in this research project, we focus on the first task, which is the detection of mandatory information. So our system is composed from two modules. The first one segments privacy policies into paragraphs, and then we predict data practices from each paragraph. The data practices are then used as input to the second module of the system, which is a rule-based model, in order to detect the mandatory information that are mentioned in the privacy policy. And first, I will walk you through the algorithms we built for the extraction of data practices. So we use machine learning and as a training data set, we used the OPP-115 Corpus, which contains 115 privacy policies annotated and publicly released by researchers of the Usable Privacy Project. And as you can see, the taxonomy is hierarchical, and it is composed of 10 categories of data practices. And here we show only the categories that we used for the compliance checking. And each category has a set of attributes, and each attribute has a set of predefined values. So here we have an example of an annotated segment from IMDb privacy policy. And the annotator first selected the first party collection use category. And this category has different attributes, such as personal information type. And the annotator selects the values of these attributes by reading this segment. And the annotator also highlights the text in the segment that corresponds to the value. So for example, for the value computer information, the annotator highlighted login password. And so since the the taxonomy is hierarchical, first level, we have the categories, and each category has children attributes. And for each attribute, we need to predict the values. We treat this problem as hierarchical multi-label text classification task. And we experiment with two approaches. We first try the local classifiers approach, and then a second approach, which is based on a text-to-text framework. The training dataset is composed of 115 privacy policies, which is small in comparison to the label's size. So in order to obtain good performance, one common ingredient for both local classifiers and text-to-text approach is to use transfer learning, where first a language model is pre-trained on a large data set of online text, and then the learned knowledge is transferred to train data practice predictor on the dataset of annotated privacy policies. So for the local classifiers approach, at the training time, we need to train one local multi-label classifier to predict the higher level categories, and then one local multi-label classifier for each attribute to predict the values for that attribute. And as you can see here, the training for this set of local classifier is done independently from each other. And at inference time, the predictions are made in a top-down order, where first categories are predicted by the higher level local classifier. And then for each attribute associated with the predicted categories, for example, if we only predicted this category, we would only use the local classifiers associated with these attributes in order to predict their values. And for the local classifiers, we choose to use the same local classifier for all the levels and the nodes. And we first reproduce prior work by the authors of policies and use a convolutional neural network as the base classifier. Segments are first embedded with word embeddings that were trained on more than 130,000 privacy policies. And this allows us to have a good baseline to compare with the other approaches. And since the state of the art these recent years is transformers for NLP tasks, so we conduct a second experiment by using a transformer model, and precisely the ExcelNet model, which we first used the pre-trained one, which is publicly available, and then we fine-tune it first for the prediction of the categories, and then to predict the attributes values, which means that we fine-tune it 21 times for the 21 tasks. And here are the results for both tasks and for this approach of local classifiers, and by both the convolution neural networks model and the ExcelNet model. And as you can see here, for the first task, ExcelNet has superior performance comparing to CNN for the task of categories prediction. However, it has a significantly lower performance than CNN for the second task. And we think that it is the case because there are enough examples to fine-tune ExcelNet for the first task, but not enough for values prediction, given that ExcelNet is much larger than CNN. And so the results are of the classifiers are good for certain tasks and categories, but the local classifiers approach has two main drawbacks. The first one is that it trains the set of local classifiers independently, so the classes hierarchy isn't captured, and the classes hierarchy is important if we want to improve the predictions of the values. And the second drawback is that the number of classifiers grows linearly with the size of the label hierarchy, which means we need more compute power and time, both for the training time and inference time. To deal with these limitations, we suggest to use a text-to-text approach. Why? Because text-to-text frameworks cast every NLP task into a text-to-text problems, such that both the input and output are text. And the main advantage of this is that we can use the same model for all the NLP tasks. So for example, even this task of computing the semantic similarity between sentence 1 and sentence 2, which is a regression task since the output is a number, could be converted to a text-to-text task, and it could be solved using the same model that was used for translation or for summarization. And we use T5, which is a pre-trained language model based on the transformer architecture to implement the text-to-text approach for our task of data practices prediction. We first need to convert the task of extracting data practices into text-to-text. We do this by first splitting this task into two tasks. The first one is to predict the categories for the segment, and the second one is to predict then the values and also the span of text corresponding to the values. And we prepare the first task of categories prediction by prepending the categories prediction prefix to the text of segments. And for the target, we convert it by generating a sequence of the categories and separating them by a semicolon. And for the second task, which is the prediction of the values, we convert it to similarly to reading comprehension task, where we use the prefix values prediction and context to indicate to the model what is the segment from which we want to predict the values and also extract the text. And we give it also the category in order to keep the hierarchy in the model, and also the attribute for which we want to know the value. And the target is transformed by first by starting with the span of text we want to extract, and by putting between brackets the value of the attribute. Once we pre-process the data and we convert it into a text-to-text format, we fine-tune the G5 by fine-tuning the largest available model, which has 11 billion parameters on these tasks. And we try two fine-tuning methods. So G5 could either be fine-tuned in an independent way, such that we first fine-tune it on the task of categories prediction, and then on the task of values prediction. And in this way, we have two models. And the second way to do it is to fine-tune it in a multi-task setting on a mixture of both tasks to capture the global labels hierarchy. And when we look at the results, we see that the both ways of fine-tuning have close recall and for both tasks, but the precision is significantly higher when we fine-tune on each task separately, which is what the authors of G5 recommended. And the performance for span extraction is good for a baseline, but we think that it is low in comparison with the performance of the same model G5 on similar tasks such as reading comprehension or named entity recognition. So we need to work more on this task. And as a global comparison between the two approaches of local classifiers and text-to-text, both XNet and G5 performs significantly higher than CNN for the first task, but the performance is at best similar to CNN for the second task. And for later experiments, we select to work with the G5 because of both the performance and is also capable of doing span extraction, with which the local classifiers cannot do. And once we finish extracting the data practices, then we feed them to the second model of our system in order to detect the mandatory informations. Here we list the mandatory informations that our legal experts were able to encode using the OPP taxonomy. So this taxonomy was created before GDPR, so we weren't able to encode all the mandatory informations because it doesn't contain all the concepts needed for the GDPR. And we choose JSON logic to serialize obtained rules because it comes with a parser that we use to build a first order logic inference engine with Python. And here is an example of encoding a rule that states the obligation of mentioning the purpose of the processing of personal data. And for evaluation of this part of mandatory information, we created 2 data sets annotated with the mandatory information, 15 pre-GDPR privacy policies and 15 post-GDPR privacy policies. And we noticed that most of the errors on the OPP privacy policies are caused by the difficulty of aligning OPP concepts with GDPR. So, for example, to encode data retention period, we use the retention period attribute. However, it doesn't correspond to what is required by the GDPR. And in the other hand, the majority of errors on the post-GDPR policies are when the algorithm does not detect the right to data portability. And this is expected because data portability has not been widely adopted before the GDPR. And so the training data set didn't contain that concept, and therefore the algorithm and inference time wasn't able to capture it very well. And the bonus with the G5 is that it is capable of predicting new categories of data practices due to its language understanding capability that enable few and zero-shot inference. So when we gave segments from post-GDPR privacy policies, it was able to predict new categories that weren't in the training data set, but that they correspond to concepts from GDPR articles such as legitimate interest or data minimization. And this could be helpful if we want, for example, to create a GDPR taxonomy from compliance documents. And to conclude our work, I like to say that this work consisted in the creation of a framework to implement automated GDPR compliance in the data supply chain. And we proposed an automatic way based on machine learning and a rule-based model to implement the detection of mandatory information from privacy policies. And we also dealt with the limitations of local classifiers by suggesting a text-to-text framework. And you could test with our approach since we released the models and data sets that you could find on GitHub. And for future work, we would like to apply the compliance framework to other documents such as the DPIAs and define what would be the compliance tasks to verify the compliance of these documents, implemented in a way that takes into account that companies and work with multi-documents. So we need to check in a multi-document setting. And of course, create data sets that are annotated with GDPR taxonomy, especially if we want to work with other compliance documents. So thank you all for your attentions, and I would be happy to answer any question.
Thank you very much, Mrs. Elhandani, and also Mr. David Restrepo here with us in the Zoom room. for your brilliant presentation, your brilliant paper. We have collected a few questions from the audience, and I would like to pose the first question from Mr. André L. from University of São Paulo, Brazil. So Mr. André L. says, in which level of applying NLP do extracting information from legal documents could, in fact, shape the law? Isn't there a risk of such rules to be tautological?
I think David could answer this question much better than me. We had several discussions about it. So let him answer.
Thank you, Andrea, for the question. Let's make sure I'm understanding the question right. So I guess what we are, what we are trying to do in this paper is to identify the provisions in privacy policies that contain some legal obligations in relation to protection of data, and to verify their compliance to GDPR. So the risks or the way this can shape the law, if we think about the pipeline that Raja described at the beginning of the paper, which is checking compliance in the supply chain, this meaning in the different contracts between processors and sub-processors or subcontractors. The risk is that the extraction of information through NLP from the documents becomes the main focus of compliance checking. And by becoming the main focus of compliance checking, ultimately becomes in practice, what actors are interested to comply with. So in other words, that we comply with what can be verified or can be extracted with NLP from legal documents. At least this is what the audit, if this can be implemented, could mean. So we have been working in this project with industrial partners who have this compliance chain, and potentially the fact that we extract some information from these privacy policies or privacy documents could mean the focus of compliance, and then legal obligations will be there. And if there is a risk that such rules become tautological, I'm not really sure exactly what it means. Maybe that we are always extracting, because of the way the tool is designed, the same type of rules from the text. Andrew, correct me if that's...
Yes, it is.
Yeah, so indeed, I mean, I guess what is interesting from the paper we just showed, so I agree as a base with what you're with that. What we can take from this paper in addition to that is that there is the possibility of predicting categories that were not originally in the data set. And I think this is an interesting progress that we made in this paper, showing that there is a way of going beyond the training data set. But of course, there is some limitations to that. So there is indeed a risk. And I guess without giving much more detail, that's why we need some decision-making process that has humans in the loop, to be brief in the answer. Thanks for the questions. I think the second one is more for Raja, but I'm happy Raja to take a little bit on it as well.
Yes.
Mm-hmm.
I would like just to read so the public can have it as well. We have here in our private chats the second question, but also from Mr. André L. from University of São Paulo. So Mr. André says, would it help if laws were written in UML models so there is no margin for different interpretations about it, at least in the field like compliance to data protection?
Yeah, I think this would definitely help. I'm not sure to what extent is possible, and I let David like extends on this. But for me, as a data scientist, this is something that would help me greatly. If especially for example, creating the training data set and the taxonomy that goes with it. So I would like not only maybe to that laws are written in a machine readable format, but why not, if we're going to use machine learning to automate, why not give also examples of training data that could automate some parts of these laws.
Maybe the only thing I can add to that is I would think that a slightly different but similar approach would be to do what the GLML consortium is doing. I don't know if you're familiar with it. It's called General Purpose Legal Markup Language. And this is used mostly for trading bonds in markets. And the idea of this GLML is it's a general purpose language markup, as I mentioned before. And the idea is that it's both machine readable, so it's a markup language, and human readable. So basically allowing some automation in the execution of transactions, bonds and others, but at the same time allowing review by lawyers of the documents. So I think this is an interesting way forward that we could use also for data protection.
And I would like to add that so for the compliance checking, there is an intermediate step actually of built in what is the checklist that we want to check, and this is like which we convert into learning tasks. So so even I think if we have the laws written in UML models, we still need to build this checklist for the compliance checking.
Thank you very much, Mrs. El-Hamdani, Mr. Restrepo, for your brilliant work. Now you have one last minute for final words, and then we follow with our next paper.
Yeah, so for final word, I would like to thank all the team that worked on this paper. It was a great collaboration, both between two institutions and also to kind of profile data scientists and legal experts. And also would like to address to the community the need that we need to create data sets such as this, but that are adapted to GDPR.
Thank you very much once again, Mrs. El-Hamdani. And now with great pleasure, straight from Italy, I would like to call to main stage, Mr. Giovanni Sato, with a short paper presentation called The Burden of Persuasion in Structured Argumentation. So please, Mr. Giovanni Sato, the stage is yours.
I share the screen. Okay, share. Okay, so I hope the screen can be, the slides can be seen. So in this presentation, I will address an issue which has been discussed for some time within the AI and law and argumentation community, which is the issue on how to model burdens of proof. Sorry. Okay, let me go on. So this is an issue that has significance for many domains, not just in the law, but certainly it is a lot of significance for the law, since the burden of proof is a key issue both in criminal but also in civil procedures. And a distinction has been introduced between the burden of persuasion, which concerns what kind of evidence need to be provided for a claim to be sufficiently supported to be taken into consideration, and the burden of persuasion that consists instead on the necessity of providing a dialectically convincing argument, which is an argument which prevails over the objections against it. There has been various proposals to deal with that. In the model that I developed together with Henry Praken some time ago, the idea would be that a claim burdened with persuasion would be defeated, strictly defeated, by an argument not being burdened in the same way. And the idea was also proposed that you have to consider the dialectical status of the concerned arguments in order to determine whether an argument burdened with persuasion survives challenges. Let me give you an example to clarify the point. So assume that you have a case in medical malpractice. It is established that the doctor caused indeed harm to the patient. You have a rule that says that puts the burden of proof on doctors, says that doctors are liable to compensate the patient if they cause harm to the patient and they cannot prove that they have been diligent. But then there is another rule that says that doctors are diligent, are not diligent if they failed to follow the guidelines. And it is uncertain whether the doctor followed the guidelines or not. Let us assume that patients, as usual, since they are the plaintiff, have the burden of persuasion on doctors' liability. However, the doctors have the burden of persuasion on doctors' diligence. So doctors have to provide a convincing argument that they were diligent. Otherwise, we may say that they are assumed to be not diligent. So this is the kind of issue that on which I would like to show you the problem that we get if we apply the standard kind of labeling that is used, standard kind of semantics that is used in usually in argumentation semantics. Here I am referring mostly to the kind of model that are based on ASPIC plus as a knowledge representation approach, and also for the semantics. So if you go with the usual semantics, what is the problem that you get? The problem that you get is that when an argument is uncertain, also the larger argument that include that argument are uncertain, and therefore it is not possible to get sure, definite outcome when an argument appears to be attacked by something that is uncertain. Let me clarify with the example. So here, if you look at the diagram to the left of the screen, you have the conflict between two arguments, one claiming that the guidelines were followed, A1, the other claiming that the guidelines were not followed, which would be B1. A1 and B1 therefore would be uncertain because they defeat one another, and we have no way of establishing which one prevails. But then we have the situation in which the argument according to one of these arguments there was diligence, according to the other there was no diligence, which are the arguments A1 and A2 and B2 on the diagram. And these two arguments also appear to be uncertain because they clash one against the other. As a consequence of this uncertainty, also the argument for the liability of the doctor becomes uncertain. So in the end, we cannot come to any conclusion, any justified conclusions in this case. Our argumentation remains uncertain. However, this is not what happens in legal cases of this kind, where on the contrary, given the knowledge that I have, the case that as I have presented it before, it appears that we can get to a definite outcome. And the definite outcome that we get is indeed that the doctor should be considered to be liable. Why? Because she failed to establish that she used due diligence. And she failed to do that because she had the burden of persuasion on due diligence and she couldn't build a convincing argument on that. Why couldn't she build a convincing argument? Because it remains uncertain whether she followed the guidelines or not. So the problem that we have in this case is that we have an argument, the argument for the due diligence of the doctor, that is not merely uncertain, it is to be discarded because it is uncertain, since it is affected by a doubt on one sub-argument of it, and there is the burden of persuasion on that argument. So the issue for us was to build a semantics that gives the right outcome, as you can see in the right side of the screen. So in this case, look, we have the clash between the argument according to which the guidelines were followed or not. This clash determines an uncertainty of whether the doctor exercised due diligence, but since there is a burden of persuasion on due diligence, then the argument for due diligence, that is B2, is not simply uncertain, but it is out. So the effort that is explained in the paper, and you have to read, if you're interested, you have to read the paper to see the details, is how to make a semantics in which an argument becomes discarded when one of its sub-arguments is uncertain. Okay, here I have another example, but we can skip over it. So the idea is that we use the burden of persuasion to adjudicate conflict between arguments, in addition to superiority. So when an argument is burdened with persuasion, it loses against a competing argument, all the rest being equal. But then we also defined the status of an argument based on the burden of persuasion. And the idea is that an argument with the burden of persuasion on its conclusion, such as the argument that the doctor was diligent, is out whenever one of its sub-arguments is uncertain. In our case, the uncertain sub-argument was the sub-argument concerning whether or not the doctor followed the guidelines. So I go towards the end of the paper. I skip this part of the graft of the presentation. I just focus on the labeling semantics, just to clarify how the formal definition on what I have just stated. So if you look at point 2 in this definition, we have that an argument is out when there is a burden of persuasion on this argument, on the conclusion of this argument is burdened with persuasion, and there is an attacker against the argument or also against a sub-argument of it, which is not only accepted, but also uncertain. And on this basis, we can get the right outcome in the example that I have just mentioned. I think that my time is running out. This model can be developed in various ways. One way is to include also reasoning about burdens. This can be an easy extension, taking into account not only burdens but also standards of proof. That is the extent to which one argument must prevail over another argument in order to fend off the attack. But this will be for further work. So I would like to thank you very much for your attention, and I look forward to your questions.
Thank you very much, Professor Giovanni Sato, for your brilliant presentation. We have a question from the audience, from Mr. Governatori, who says, what is the difference with the feasible logic with ambiguity blocking and ambiguity propagation?
Okay,
Here.
now thanks for this question. I think that indeed it would be there is a connection, and I think I suggested that at some point in an email to Guido himself that it would be good to study the connection between these semantics and what can be done with these approaches to the feasible logic. Is indeed, I think that ambiguity blocking is similar to what happens with the burden of persuasion in our model. And the interesting thing would be to combine in the same reasoning items on which there is the ambiguity blocking and items in which there is ambiguity propagation. But I think it would be interesting to study the connection between these two approaches.
Mr. Giovanni, now you have 1 minute for final words.
Okay, no, just I think that, as I said, the burden of persuasion is a critical topic for the theory of argumentation, and this aspect that that we have addressed in this paper, I think has not been addressed so far. I believe that finding an adequate formal way to approach it is important for modeling argumentation in the law, and I think in general for the computational models of arguments. And no, I hope to be able to develop this line of research, and one promising direction is the one that was just mentioned by Guido in his previous question.
Thank you very much, Professor Giovanni. It is a great pleasure to have you here with us. And now, following our panel, I'd like to call to main stage, straightly from Netherlands, Mr. Cornelis Cor Stegen. Please, Mr. Stegen, you have the stage.
Thank you. Good morning, everyone. First of all, I'm very honored to be here. I would like to give my thanks to all of the organizers and everyone involved. My name is Cor Stegen. I'm a PhD student from the University of Groningen from the Netherlands. And as part of the National Hybrid Intelligence Center, our aim is to combine human and machine intelligence. So to expand human intellect rather than to replace it. And one of the challenges that we face is explainability. And though I personally am by no means an expert in the field of law, because my background is in AI and I worked as a machine learning engineer in industry. But what I do know is that explainability is also one of the most crucial aspects in AI systems, in AI and law. Because if a system cannot be explained, it cannot be justified. And systems that cannot explain their decision-making, therefore seemingly have no place in AI and law. Current state of the art machine learning systems, on the other hand, like deep learning, are exactly examples of such systems that cannot explain their decision making. They are black box systems. And this is unfortunate because their performance in terms of making autonomous decisions is, of course, outstanding and beats standard knowledge-driven methods. And this conflict between, on the one hand, the high performance and on the other hand, a lack of transparency has now led to the well-known field of explainable AI. And using explainable AI techniques, the decision-making process of such black box systems can be explained. And even though these methods are still far from perfect, they are making some substantial steps forward. But for us, however, this is where the problem starts. This is because explainable AI techniques have highlighted an interesting phenomenon. For example, using the LIME method, a wolf versus husky classifier is explained. And this classifier performed well in terms of accuracy, But when we take a look at the reasoning behind its decision making, we see something interesting. This husky here is classified as a wolf because there is snow in the background, a seemingly irrelevant detail. It should at least be irrelevant in the classification process. And this strange phenomenon arises even with high classification accuracies and has been shown time and time again. Think, for example, of adversarial attacks, wherein just a slight perturbation of an image can lead to drastically different predictions. And we refer to this phenomenon as systems that perform well, but for the wrong reasons. Explainability alone is therefore insufficient in our goals of AI and law. Explaining unsound decisions does not make it sound. Instead, we want something more. We want systems that perform well for the right reasons. What we want is we want responsible systems. And we are now working towards a method that can act as a first step into reaching that goal, a method to evaluate the decision-making of a system, or in other words, a method for rationale evaluation. And here we define the rationale of a system as the reasoning that that system uses to come to its decisions. The method that we propose is model agnostic and should therefore work with any machine learning system because it's more of a generalized concept that is driven by knowledge from domain experts in order to evaluate the learned rationale of a system. We believe that by aligning learning and reasoning, we can potentially achieve a best of both worlds situation. And our method is very loosely based on the idea of unit testing in software, in professional software development, when you write tests for each of the smaller components or functions of your code. Now, the method that we propose consists of 3 distinct steps. First of all, we measure the accuracy of a trained system, and we proceed only if the accuracy is sufficiently high. Of course, sufficiently high in this sense is subjective and is based on the specific problem at hand. But the point of this first step is that if the accuracy is not sufficiently high, then the rationale will not be sound either. So there's no point in evaluating it. Now, in step 2, we design dedicated test sets for rationale evaluation, targeting selected rationale elements based on expert knowledge of the domain. And these test sets are designed such that systems can only perform well on these test sets if it has learned the specifically targeted element of the domain. And lastly, we evaluate the rationale through the performance of the trained systems on these dedicated test sets. And furthermore, based on this evaluation, so based on this entire method, the training data can then be adjusted to improve the rationale, again, based on knowledge of the domain. We performed a couple of experiments in which we illustrated our method, and in each experiment, we aim to use our method to evaluate the rationale of a system, so the reasoning behind its decision-making. All of the data that we use is artificially generated, based on knowledge structures of fictional and non-fictional legal domains. And each domain can be defined explicitly as a set of conditions. And this was intentional, as this makes it possible to compare these conditions to the rationale of the system. In other words, we have an objective ground truth to compare to. And though they are simple toy domains, they were chosen to introduce and to illustrate our method in an objective manner. We first replicated a study done by Ben Schapen in 1993. As this study inspired us, and it illustrates the current issues regarding responsible AI in a very intuitive manner. It investigated the soundness of the rationale of neural networks through the use of artificially generated data. And this data was based on a fictional domain in which pensioners were eligible for a welfare benefit if and only if they satisfied 6 conditions. And these 6 conditions are expressed logically here on the right of the slide. If and only if all these 6 conditions evaluate to true, the label, eligibility, also evaluates to true. What we did is we replicated this study using more data with standard state-of-the-art multi-layered perceptrons. We even introduced a simplified version of the domain and did all of this to see whether the claims that were made back then still hold today. And they do. When we train and test a neural network on these data sets, they initially attain very high accuracy scores of around 99% on this fictional welfare benefit domain. So step 1 of our method, which is checking whether the accuracy is sufficiently high, is therefore completed. According to the second step of our method, we generate 2 dedicated test sets, which are designed specifically to measure how well these 6 conditions are learned, or at least 2 of these 6 conditions. By testing trained networks on these data sets, which is step 3 of our method, we discovered that the system was unable to learn both of these conditions. Systems can therefore attain high accuracies while only really knowing 4 out of the 6 conditions that define the domain. And even with modern MLPs, multi-layer perceptrons, with more data and by simplifying the domain, the same results still stand. We have high accuracies while not knowing all of the conditions that define the data. Or in other words, we have an unsound rationale. By adjusting the training data based on this evaluation, the initial accuracies remain almost the same, but the individual conditions are learned significantly better. An example of this can be seen in these graphs. These display just 1 out of the 6 conditions that a system had to learn. So first on the left, we see an ideal graph, what we would like to expect. And in the middle, we see the actual graph. What we can conclude is that the system was not able to approximate the condition. After adjusting the training set based on our evaluation, the graph on the right, the results look a lot better. After replicating the study using the fictional welfare benefit domain, we set out to employ our method in the non-fictional domain of Dutch tort law. And unlike in some countries, Dutch tort law is a statutory law and not a case law. And it describes whether or not there are duties to repair someone's damages given a set of facts, which can be represented as an argumentation diagram as shown here on the right. We can represent this diagram as a set of conditions as well, just as before, as shown here on the bottom of the slide. And again, if and only if all of the conditions evaluate to true, the label evaluates to true. In other words, in that case, there's a duty to repair damages. The network should therefore learn all of the 5 conditions. Again, we generate all kinds of data sets using this domain, and we train neural networks on the data set. Of course, our goal is to investigate how well the conditions are learned. And in particular, we wish to investigate whether the systems are able to learn the notions of unlawfulness and imputability. And just as in the replication study, and according to step 2 of our method, we therefore generate a dedicated test set for both of these conditions, on which a trained system could only perform well if it has learned said condition. What we discovered is the following. First of all, we get high accuracies on a normal test set of above 98%. It is therefore possible to approximate Dutch tort law with a subset of the cases. And step 1 of our method, to measure whether the accuracy is sufficiently high, is therefore complete. When we investigate the performance of the same networks on the dedicated test set, step 3 of our method, we see that despite high accuracies on the regular classification task, one of the 5 conditions, imputability, was hardly learned at all. So to conclude, we have reaffirmed that a high performance does not guarantee a sound rationale. Accuracies alone are therefore insufficient. We need something more. So secondly, we also introduce a knowledge-driven, model-agnostic method for rationale evaluation. And in future research, we would like to expand upon this method, such that the soundness of the rationale can become more tangible and that its quality can be asserted. We should again here note that both the machine learning algorithms and the domains that we use in these experiments are toy scenarios to illustrate our methods. We chose MLPs because they are simple black box systems, but our method is generalizable to the most advanced deep learning systems since it is completely model agnostic. We also explicitly chose to use artificial data based on a set of conditions, as these conditions act as our ground truth, thus making it possible to objectively evaluate the rationale of the system. In the future, we might expand to real-life data sets where the ground truth is not as explicit. And in those cases, our method would still rely on the domain knowledge of experts, because in cooperation with these domain experts, we can create dedicated test sets that evaluate specific components of a desired rationale. And we can then compare that to the actual rationale. And this hybrid approach of combining knowledge with reasoning can hopefully move us towards an AI that is not only explainable, but truly responsible. So thank you all very much for your attention. I would be honored to answer any of your questions.
Thank you very much, Mr. Stegen, for your brilliant presentation. Now we have a special question from the audience. First, a comment. Mr. Trevor Bench-Capon is here with us. He's saying that it's a very nice work, and he has a question. He says, where is the evidence that ML-based systems are more accurate? Generally report success around 80% against 90% for traditional methods. They are quick, but not more accurate.
Right. Thank you very much, Trevor, for that brilliant question. It's a very good one because, of course, that was a generalized statement that doesn't hold in every situation. Of course, when we expand our view beyond just law, we see that in things like computer vision, speech recognition, all these other kinds of domains. Machine learning works significantly better than standard good old-fashioned AI. And therefore, our philosophy is that we shouldn't completely abandon machine learning because it is not explainable or works just as well as good old-fashioned explainable AI techniques. So therefore, we wish to investigate these very deep and at the moment state-of-the-art systems so that we can use this as well. But thank you for your question.
Thank you, Mr. Stegin. Now you have 1 minute for final words.
All right. So I would again like to thank everyone involved in the ICAIL, so the organizers, the speakers, and of course also the audience for listening. Furthermore, I would like to give my thanks to the co-authors of this paper, to Bart and Celia, also to the Hybrid Intelligence Center for making this work possible, and of course a special thanks to Trevor Bench-Capen for inspiring us. We aim to continue our work on this method of rationale evaluation such that we can move forward towards AI that is both explainable and responsible. Thank you very much.
Thank you very much, Mr. Stegin, for your brilliant work. And now, finally, we have a full paper from Professor Juliano Maranhão, Professor Giovanni Sartor, and Professor Edelcio Souza, which will be replayed here on stage. And right after, Mr. Juliano Maranhão and also Professor Giovanni Sato will be here to answer to questions from the audience. So now we have the paper.
Good afternoon to all, or depends on the time zone. So hello to everyone. I'm going to present our paper now. I'm going to share the screen. Is it visible for everybody? Okay. So the paper is, the title of the paper is A Dynamic Model for Balancing Values. It's a joint work by myself, Juliano Maranhão, representing the University of São Paulo Law School, the Center for AI at the University of São Paulo, and the Logarithm Institute. And also Edelcio Gonçalves de Souza, a co-author, a colleague at the University of São Paulo and Logarithm, and Giovanni Sartor from the University of Bologna and the European University Institute. Our goal, our short-run goal in this paper is to model reasoning with rules and values. There is an apparent consensus that applying the law is not limited to applying rules, but also to apply rules in consideration of underlying values. There are at least three ways in which rules and values are interconnected in legal adjudication and legal reasoning. The first one is that values are a critical framework for assessing the merits of positive laws. That is, values are used as an assessment to the extent to which the rules meet some standards of justice and fairness, and therefore this may affect the validity of rules. There are different legal theories to approach what is the particular relation between law and morality and with respect to the validity of rules. The second way that values are relevant in the application of rules is it regards interpretation. So in interpretation, when the interpreter selects alternative meanings to legal terms, it considers underlying values and teleology. That is, the extent to which the rule, the meaning which is ascribed to the rule, better promotes or demotes relevant values of the community. And the third way in which values and rules are interrelated is regards the proportionality reasoning in constitutional and human rights assessment. That is, if there is an infringement of constitutional right, this infringement is assessed with respect to advantages regarding other constitutional rights and fundamental rights and values, and it's assessed if there is a better trade-off in this conflict between constitutional values. So also here there is a choice between the underlying morality, public policies, or fundamental rights, which are relevant for the application of rules. So since these values are also relevant for interpretation, the long-run goal of this research is to contribute for the tenet of making the law computable, given that to providing logical models to represent law in a computable way. So this research is connected with, is a continuum with respect to previous research. The first one presented at ICAIL 2017, where we discussed a logical architecture for dynamic of legal interpretation. We were concerned with the interplay between changing rules and changing meaning ascription and changing values which are underlying those rules. Then in Dion 2018, a paper with Edelso Souza about the contraction of constitutional and constitutive and regulative rules. And then Maranhão and Sartor in ICAIL 2019, we assessed how the balance of values may affect and change legal rules. And in Dion 2020, a paper with Sartor called Interpretive Normative Systems, we assessed different legal theories regarding the relation between law and morality. As a running example to our model, we have used the Riley versus California case judged by the US Supreme Court in 2014. According to the law at the time, police officers were permitted to access the content of any item found with the arrestee in an arrest. And then a new question was raised by this case, which was, is it permitted to access also the digital content of the arrestee's mobile phone? And the answer by the Supreme Court at this time was no, that is, the police must obtain warrant to search cell phones. And this was based on a consideration of underlying values. Specifically, it was argued that in this case, there is a significant impact on the privacy of the arrestee if the digital content of the mobile phone is accessed. So in the balance of values regarding safety and privacy, in this case, privacy would outweigh safety, and therefore it should be forbidden to access this particular property item of the arrestee. So we would like to model it, and in particular to understand how is this balance between competing values and how they affect legal interpretation. But we are going to focus on arguments about values which are demoted against values which are promoted by the action at stake. I'm not going into the details of the formalism, but
recording in progress.
I'm not going to the details of the formalism, but I'm trying to show how the model works using the example given by Riley versus California. So the whole game here in this model is to compare those values which are demoted against the values which are promoted by the action at stake, given a certain constellation of factors. So we divide the values which are relevant within those which are demoted and those which are promoted, and use an impact function to assess whether the action impacts the demotion or the promotion of a given value, and also use factors that may intensify or attenuate the impact of such values. So the idea is that we compare the proportional impact on the and aggregate impact on the demoted values with the proportional and aggregate impact on the promoted values. And if the demoted values beat the promoted values, then we have a reason to forbid the action at stake. Otherwise, we have a reason, if the promoted values are stronger than the demoted values, then we have, or equal to the demoted values, we have a reason to permit the action given that constellation of factors. And so there is also a connection with argumentation with this approach, since we know that the argument bringing values which are relevant and has some hierarchy within the field of underlying values to rules, and then arguing that actions may impact those values, are arguments to the fact that there is a reason to forbid a certain action, or there is a reason to permit this action. So we wanted also to bring this argumentative dimension, but we model it by means of change functions. So let me give an example of the additive model that we have used. We have await functions taking values to the interval of real numbers 0 to 1, and they are going to represent dimensions of relative importance of these values and a hierarchy between the values at stake. And then an impact functions that take factors and values and represent the impact, an impact function for each action, and it represents the impact of the action in the value, and actually the influence that factors may have on the impact of the action on such values. And this impact may be positive. This influence of the factors on the impact of the action on values may be positive, or it may be negative. If it is positive, we call the factor an intensifier. And if it's negative, we call the factor attenuator. Of course, one may argue that there is some arbitrary choice between the interval of real numbers that we assign to weight of functions and to impact of factors or of actions on the values. But actually, this is just a model to try to represent reasoning with dimensions and magnitudes. So any scale may be used to represent this impact. It can be an interval of 3 points, for instance, low, medium, and high. It could be of 5 points, low, medium, medium, high, and high, and so on and so forth. It depends on each model of representation that one would like to use. But the fact is that there is a rationality using this dimension, and that's what we want to capture. So here in the example, if we consider the impact of the action on a certain value, we call it a baseline impact if there is no factors to be considered. So in this case, in the Rilo versus California case, we are concerned with the impact of the action of accessing an item which is found with the RST. So accessing any item has a baseline impact of 0.4 on privacy, and privacy has some weight. The proportional impact is the product of the impact and the weight of the value. So here we have, in a baseline situation where there is no factor considered, we know that we have that the privacy, the impact on privacy of the action of accessing outweighs the impact on safety, since there is no charge against the individual. Then the result is that the demotion of values is stronger than the promotion, so the action is forbidden to access. But we may consider intensifier factors. For instance, the factor that there is an arrest intensify the impacts on safety by the action of accessing. And therefore, if you consider the product with the relative importance of safety, we will have that the balance shifts, now making the action permitted in the case of an arrest. And if we move now for a consideration of property rights, the factor that there is a property item, then this increases the impact now on the demotion of property rights, but it's not sufficient yet to beat the promoted values. And therefore, it is still permitted to access the items if there is an arrest and it's a property item. However, if we consider a mobile phone, then this is another intensifier that intensify, as the Supreme Court said, significantly the impact on privacy. And this makes that the aggregate impacts on the demoted value becomes stronger than the aggregate impacts on the promoted values, which means that if there is an arrest, it is a property item, but it is a mobile phone, then the balance says that there is a reason to forbid the action of accessing the digital content of this mobile phone. But factors may have also an attenuating influence on the impact of action on values. For instance, if we consider that the mobile phone is not a personal one, but is a professional one where only professional content is allowed, then this would attenuate the impact on privacy and may shift the balance again for an authorization to access the content if the mobile phone is not personal. So that's how the game is played within the additive model. But our main concern and contribution in this paper was to describe how the shifts of balance occur if we add factors, or if we contract factors, or if we add values, or if we contract, delete values from the model to be considered. And this may reflect argumentation so that there is a factor to the fact that there is a factor that was not considered, or to the fact that there is a factor that actually is not present, and therefore this will change and shift the resulting deontic status of the action at stake. So the goal was then to describe balance shifts by changing either the set of factors or by changing the set of values. If in this game we are concerned about who's going to win, is it going to be the demoted values or the promoted values in the balance? So if we consider a situation where the demoted values beats the promoted values, it makes the action forbidden, and we want to know now how this balance may be shifted. There are two ways, basically, in which this value may be shifted by the addition of new factors. It may be a strengthening of the opponent, that is, a strengthening of the promoted values, and we may strengthen the opponent by adding intensifying factors to it. We called it a factor rebutting expansion function. Rebutting because it looks like a rebutting in structural argumentation, since we're going to come with a new opponent to the argument and strengthen the opponent. So for factor rebooting expansion function, you add factors which intensify the impact of the action on the promoted values. But it may be an undercutting if we weaken the winner. And we do that by adding attenuating factors. Now, we also may shift the balance by contraction, by deleting some factors. So if we delete factors which attenuate the impact of the action on the promoted values, we have a factor rebooting contraction function, because we are deleting attenuators of the opponent. So we make the opponent stronger. But we may also delete intensifiers of the winner. So we may weaken the winner. This would be the case of a factor undercutting contraction function. So let me show how this could work in the example. Suppose we have this previous argument position, and then we have as values promoted privacy and values demoted privacy and promoted safety. And now we are going to add a new factor by a rebooting expansion function. This new factor increase the strength of the promoted values, and therefore it beated the previous argument position where the action was forbidden because the demoted values were stronger than the promoted values. Now we add that is the context of an arrest, and therefore this will activate the value of safety, and therefore it shifts the balance to a permission of the leading to a permission of the action in the context of an arrest. Now, to represent a contraction, let us suppose then that we have this as our previous position, and we delete the arrest and safety. So we had before that the promotion of values beated the demotion of values, making the action permitted. But now, if we deleted the arrest and say that the arrest was invalid, or that there was not an arrest as an argument, this will shift again the balance, making thus the action forbidden. And this would be an undercutting contraction function, since it weakens the winner by deleting an intensifier. Now, suppose we have this as an original argument position, where we have that the action is forbidden because it's an arrest of a property item, in particular of a mobile phone, and we have that the aggregate impact of the values demoted are stronger than the values promoted. Now, if we expand the set of factors by the factor that is not a personal item, this will attenuate the aggregate impact on the demotion of values, weakening the demotion of values and making it weaker than the promotion of safety. This will then have an effect of shifting the balance, and since it is an addition of an attenuator on the winner side, we call it an undercutting expansion function. Now, if we consider this as the original position, and we want to delete the factor in question, then we would have that the attenuating factor of the opponent is deleted, and therefore this is a factor rebooting contraction function that shifts again the balance. think we are ahead of the time. So with respect to with respect to the shifting of balance, we may also have the shift concerning the set of values. If we add values or if we contract or delete values, this may also lead to a shift of the balance, changing the reasons for a prohibition to reasons for a permission. This shift may be caused by a value rebutting expansion function. And what is that? If you add values promoted by the influence of intensifying factors. So if you strengthen the opponent by adding values, but you may also weaken the winner by adding values. And this will be a value undercutting expansion function. We may also have the effect of shifting balance if we use a value rebutting contraction function that is to delete an attenuating factor from, to delete a value which is promoted by the influence of an attenuating factor, or otherwise, if we have a value undercutting contraction function, if we delete values that are demoted by the influence of intensifying factors. So let me give, just to finish, an example of adding a value. Suppose we have this as an original position, and in this position, the promotion of safety beats the demotion of property rights. But then if we add into consideration the value of privacy, and we know that there is a baseline impact on privacy, then this will shift the balance by expanding the set of demoted values, by making them, since you strengthen the opponent, this is a value rebutting expansion function. And you may have an undercutting contraction function when you delete the corresponding value. And so on and so forth. These are the moves that may be described. In the paper, we have made a formal description of these functions in an AGM style. And the idea then is now to raise your interest to the paper by showing how it works in the model, but we didn't enter into the technical details. If you would like to know these technical details and the construction of these functions, please visit our paper in the proceedings. And I thank you very much for your attention.
So thank you very much, Professor Juliano, for your replay. And now you have the stage.
Okay, thank you, Roberto. There are three very interesting questions. One from ICAIL. ICAIL asks about generalizability of the influence of factors on the promotion or demotion of values, and whether we could have the same function across legal cases and domains. Trevor Bench-Capon asks about the shift of the balance by changing the weight of values. And we have a third question about comparing independent actions. I think that all these questions are related, and they are very good ones. First, related to Trevor Bench-Capon's question. Yes, it's possible to shift the balance by changing the weight of the values. And in the paper, Value Assessment and Revision in Legal Interpretation, we have used a function for that. That paper is co-authored with Giovanni Sartor. And indeed, there is disagreement about the relative importance of values, as well as there may be disagreement about the influence of a factor on the impact of the action on a value. So we may also have divergences and shifts in the ascription of impact according to this function. And actually, in our model, the the contribution of each factor for the impact of the action on the value never changes, independently of the addition of any further factor. And this is something that we want to deal with in future work by making the contribution of each factor change according to the addition of new factors. It should be probably a multiplicative model and not an additive one. But this is left for future work. And the question about changing or comparing independent actions is a very good one. And this is a tenet that we want to explore in future works. Actually, both functions, the impact function is indexed for each action. So in our model, it's not possible to compare different actions. But in order to do that, probably, as Mikhail has pointed out, we would have to generalize the function so that across a legal domain or across legal cases, so that we can compare different actions. For instance, in consumer law, you may want to compare alternatives for satisfying a consumer complaint, either by indemnization when there is a problem with a product, or by delivering a new product. These are different actions, and we would like to compare them. So this is all left for future work. And again, for Mikhail, we use, when we index the functions to a particular action, we are talking about local coherence. And it is probably the lowest level of local coherence. The coherence is very tight. We may want to broaden this coherence level, but we believe in local coherence. We will not generalize to the extent that we have a hierarchy of weights of values or impacts of actions, considering the whole global order, the whole legal order. But we think about smaller domains of coherence, for instance, maybe a field of law, or maybe the extent of a case or a certain issue. We may organize it not only by cases, but also by issues, where we have different degrees of local coherence. But we don't believe in a global coherence of the legal system, because the assignments would be too arbitrary. So I think these all three are very good questions, and they are all related to future investigations that we want to pursue. And so thank you very much for the questions. And I'm now moving for the Gather Town. For if you have more questions, please, I will be there to discuss our work. And Roberto, if you could explain then again how to go to Gather Town, I will be waiting for you there.
Okay, perfect. Thank you very much, Professor Juliano.
Thank you also from Giovanni. But
thank you, Professor Giovanni.
Giovanni is there. Giovanni, if you want to complement my answers.
I think your answers were perfect. So I'm very happy with that. Both the questions and the answers. Thanks a lot.
Thank you, Professor Giovanni and Professor Giuliano as well. And now, as Professor Giuliano requested, I'm going to show you my screen where I'm going to explain how you can enter in GatherTown and join our networking space. So I'm sharing my screen. Professor Giuliano, can you see my screen? Just to make sure.
Yes.
Okay, perfect. So you can see my screen. I'm here in GatherTown. How do you guys can enter in GatherTown? So here in our OpenFi space, there's this left part of the screen where you can click this star, which says Gather Town. And then you join here the room. And after setting up your user, you will be in this room. For example, here we have a few colleagues, Andrea from University of São Paulo. Here we have our Jus Brasil stage with Gabriel Delia representing Jus Brasil live. He will be here to talk with us about Jus Brasil and their work. Hi, Gabriel. Can you hear me?
Yes, I can hear you, Roberto. Sorry, I was listening to the YouTube feed and then I got confused because there's a little delay there. Hi.
Okay, nice to see you here. And here we have also Lucas and that. So you can join us here. Juliano will also join us for a conversation. So you are all welcome to Gather Town platform. We'll be there for networking space. Now we have a short break. We'll be using Gather Town, and we will start with the next panel in around 20 minutes. See you there. Thank you very much.